Hi, so I think we'll get going. Welcome to another webinar. Thanks to Katie and Liz for helping to put this together. Delighted to welcome Tony Littner and Tom Macleod from Harbottle Lewis. Tony is the partner that's heading up the VC practice at Harbottle Lewis, and Tom is a senior associate in the corporate team. I've personally worked with Tony for about 12 years now, so I have known him very much in the angel investing VC space and entrepreneur space. So I can vouch for his work. And I actually met him on a panel like this, and I was very impressed with the way that he could switch from the entrepreneur side to the investor side. And that's what led to me reaching out to Tony, and I guess the rest is history. They've kind of given up their time to answer a lot of your questions. We've had many posted to us before the event, so I will moderate and read some of those out. If I could ask you to please post your questions into the Q&A as we go, and I will moderate those. If we have time, you can raise your hand through the icons at the bottom. I think it's called reaction. And if you raise your hand, I can see it and I can actually allow you to speak if we've got time. But without further ado, we'll get going on the first question, which I'll pose to both of them. So, Tony and Tom, what are the biggest, most frequent mistakes you've seen entrepreneurs and investors make, and what specific legal measures or contract clauses would have protected them?
Tom, shall I kick that one off?
Yeah, sure.
So the answer is there are several. So I think we've probably seen it all in our time. In essence, there are lots of mistakes that can be made and that are made, and obviously part of the role of lawyers is sort of trying to mitigate against those and trying to sort of solve or prevent those from arising in the first place. Probably one of the biggest mistakes is actually from an entrepreneur's perspective is probably giving too much equity away on day one. So I mean, the situation is that you never, when it's your baby as a founder, you never have as much equity as you do on day one. On day one, you've got 100%, and 100% sounds like a big number, but it's actually amazing at how quickly that 100% can very quick be diluted essentially. So obviously when it gets to sort of a Series A stage of investment, you'd expect a certain level of dilution, but the key is what happens between sort of startup and Series A. And there's lots of founders start off with 100%, and somebody's maybe done a bit of development or a friend's helped them with something, and it's like, well, I'll just give 3% to this person and 5% to that person and another 2% to that person, and I've got someone who's going to come on board as a sort of an advisor, and they can get a percent, and very quickly it very quickly adds up. So I think one of the it's not really a legal issue as such, but more of a commercial issue of just trying to protect your equity and keep as much control as you can from a very early stage, knowing that dilution is a fact of life, and it's going to happen, but you want to try and avoid or postpone it from happening as long as you can. Is there anything else on that bit, Tom, you think? Yeah,
so it's a very good point, and I think linked to that is making sure that when you do give out equity to certain key people, whether it's an important developer or a key employee, or even another co-founder, so to speak, that you do have the ability to be able to claw that equity back from them in circumstances where they might decide they've had enough after a few months or a year, because you don't necessarily want to be able to allow them to keep their entire stake in that scenario. And I think we're going to touch on this in some of the later questions, but this is particularly even relevant to a co-founder scenario where two of you might start in business and you think, oh, that's great, we're going to be in this forever. And you don't think about what the consequences if someone decides to go and do something else, or gets bored, or there's a fallout. So it's about making sure you've got the right legal contractual framework in place to be able to claw that equity back if needed. And we will go on to that in more detail.
Thank you. I know that we've got both investors and entrepreneurs on the call. So you've mentioned giving away too much equity, but I've also come across founders that don't give away enough equity. They overvalue their position. What would you say about that from the investor side of things?
Yeah, it's a very good point, and you know, a lot of sort of early stage investing is, I think, as much about psychology as it is with anything else, and just understanding where both sides are coming from. So, you know, your starting point is that you have a founder who has a baby, essentially, you know, and they're very protective over their baby, and you have an investor who's putting in real hard cash, who wants to make sure that they get an appropriate amount of the company. So you're right, Charlotte, that some founders are too guarded of their equity and put in place very unrealistic valuations on their companies. And I think particularly where things like EIS are in play, because I think they almost use EIS as a way of artificially inflating the valuation of the company to factor in the tax benefit that the investors receive. So I think just some realism on either side is the key. But frankly, I feel a bit more sympathetic about investors actually getting equity and having discussions around that, you know, where they're putting in hard cash. It's a bit more of a nuanced or difficult argument where it's kind of, you know, dishing out equity to people that may have helped with some, with some bits and pieces along the road, but who may not necessarily have either contributed cash or who are going to be in it for the long haul. So that's where it kind of becomes a bit more difficult. Did you want to add anything to that bit, Tom?
I would say, while we kind of touch on equity, I think another mistake which we see sometimes is founders agreeing to take equity from somebody over a different party, where the stake that's being invested is being invested in tranches, so to speak, because when we act on the kind of investee company side and there are tranches involved, more often than not, we do see a scenario where the investor, perhaps if things aren't going as they had planned, finds a way to not make that one of the subsequent installment investments. And then you've got a problem as a founder, because in your mind, you had all that money coming in. So tranches are something to be a bit wary of. And if you do agree to them, make sure the targets are very clear, and it's kind of objective as to whether they've been hit or not. So you don't want to give an investor any grey area to be able to get out of subsequent follow-on tranches of that investment.
Okay, thank you. For the people that have just joined, we're using the Q&A box to capture your questions. If we have time, I can open up and actually let you speak. So please just post your questions in the Q&A. We started off with a bundle of questions that had come in before the event that we're going through, and as questions arrive. So as the question that's just been posted is related to what you've just said, I will ask that one. You mentioned clawing back equity in the event of a separation of the founders. How do you do that typically?
Do you want to lead on that one, Tom?
Yeah, so ideally, if you've got the resources, when you set up the business, you will also put in place what's called a co-founder agreement, which states in certain circumstances, if one of the founders quits or whatever, goes off to do something else, then the other founder or the company has the right to require that person to transfer some shares back to the founder that's staying, or to the company, or there are other mechanisms to deal with this, and often it's tax driven. But if you have something in place like that, and you've got a legal framework to be able to enforce those provisions and ensure that your equity is protected in that scenario. So there are ways of doing it. Often really early stage companies don't think about this or don't want to spend the resources. So it's always a bit of a balancing act. And sometimes we see companies wait perhaps until their next investment round when they've got a bit more cash in order to sort this kind of thing out. And that's okay, but obviously there is that period where you are on risk for something like this.
Thank you very much. So on to the next question. What are the differences and the amount of work for angel funding versus crowdfunding versus a VC round. So what are the differences and the amount of work for each of those three different types?
Yeah, so comparing sort of three very different beasts there. So I mean, you know, angel funding is obviously where the company is taking on money from individuals, from business angels. And actually, even within the sphere of angel investing, practices vary quite wildly between, you know, sort of friends, family, and fools, who will typically require very little formality and paperwork, and where, frankly, you know, they put, you know, they could just put the money in and may not even ask for a share certificate. To much more sophisticated forms of angel investing involving, you know, syndicates or clubs or associations, often which is done with some level of formality and complexity. And some, you know, some of those organisations or affiliations almost operate now with the sorts of levels of sophistication that that, you know, family offices or private equity or venture capital houses would. So obviously for business angels, a key driver tends to be tax, and that often means EIS relief, which is a whole separate subject. But broadly speaking, without sort of overcomplicating it, one of the features of EIS relief is that the angels will receive ordinary shares. So that does help to sort of limit the ability for complexity to some degree. But aside from the class of share, often some of the rights and protections sought, again, may not be that dissimilar from a venture capital type transaction. So may well involve bespoke shareholders agreements, articles, and, you know, in some cases, you know, some sort of light touch due diligence. Probably not the sort of thing that a VC would do, but at least some layer of due diligence. Do you want to touch on VC, Tom?
Yeah, sure. So I think it's right that if you are an angel investor with EIS, you typically want ordinary shares, which is converse to the position for VC investors, who will normally take preferred shares, which have, you know, a couple of key traits typically, in that they will have what's called a liquidation preference, which means that they would typically get their money back if the company is wound up, or even on a sale, if the sale is kind of not in the money and the company is sold for less than the valuation at which the investment was made by the VC. And also what's called anti-dilution rights, which means if the company goes on to do a subsequent investment round after the venture capital funds come in, but at a lower valuation, then the venture capital fund will be topped up and get some shares for free, essentially, which can dilute the founders. So they're two of the more kind of aggressive terms, which pretty much all VC funds would expect. But I think on the whole, the term sheets typically are just slightly more complicated for venture capital funds, and the long form documents as well are a bit more complex and tend to follow an industry standard on the whole, but they don't always. So I think it's quite important, if you are taking money from venture capitals, that you're properly advised and you know what's going on, really, because the whole process is slightly more convoluted. Not to say it's the most complicated thing in the world, but, you know, usually slightly more sophisticated than with angel rounds.
Yeah, and just to touch on crowdfunding, because I think that was part of the question.
Yeah.
I mean, crowdfunding, I mean, again, it depends on what the platform is, because crowdfunders vary quite dramatically. So you've got issues of, you know, what platform are you talking about, what crowdfunding platform, but also what model of crowdfunding. So whether the crowd will invest directly, the sort of direct investment model, or through a nominee structure. Because again, if they're investing directly, it may have the benefit of there being sort of less formality potentially, and less rights that the platform would take, because essentially all of the shareholders are becoming direct shareholders. But against that, you have the prospect of several hundred individuals potentially being on your cap table. Whereas if the crowdfunding investment is made through a nominee structure, then typically the nominee would want certain rights. So it often does involve some sort of, you know, crowdfunded friendly type articles with rights for the nominee, and maybe some tweaks to the to your shareholders agreement. So I mean, it's sort of, in terms of layer of complexity or process, it probably kind of sits in between angel investing and venture capital investing. But I mean, I'd stress this is not a much more sort of nuanced question.
Yeah, and just to quickly add on crowdfunding, what a lot of companies don't realize is that often to get onto the crowdfunding platforms itself, you actually have to have a cornerstone investor. So typically an angel investor who's willing to write you a large check and take up a lot of the overall round. Otherwise you can't go live on there. So often people think, oh, I'll just put my company on Seedrs or whatever, and then I'm away. That's not always the case. You do have to have generated an interest from an initial investor or investors to get going. And also just be alive to privacy issues when you do crowdfunding, because you are required to give a lot of information to the site, and anyone can pretty much become a member and look at the information you're giving, which could be quite sensitive data about the company. So competitors, for example, could get on there. So it's not necessarily for everyone, but it also is a good model, particularly if you're perhaps B2C and you want to generate a bit of publicity. You know, you get a decent advertising campaign on the tube or whatever. So it does work for some companies, but again, just give it some thought and probably think about it before you sign up to something like that.
Okay, thank you. We've had a question from the audience now. How do you deal with valuation when one founder transfers shares back? If transferred at zero price, does that create higher future cap gains liability? If at market price, then that needs to be funded. So how do you deal with that?
Yeah, so I'd jump in on this, Tony. It's a very good question, and something which founders aren't always alive to, because if you are issued with shares or you receive shares from another person and you are an employee or founder of a company, if you're not paying market value for those shares, then technically there is a tax liability there on the difference between what you paid and the market value. And you are technically obliged to declare in your income tax return that you received these shares and that you paid nothing, but that they did have this particular market value. So you do need to be a bit careful on the tax side of it, and it's always a bit of a balancing act between the tax risks and the commercial deal. Because if somebody leaves and you're going to get the shares back from them, then if they've been a bad leaver, for example, and you don't really want to pay them anything, and hopefully if in your co-founder agreement you have the ability to claw those shares back for nothing, and that's great commercially, but still be alive to the fact that if you are obtaining shares at that below market value rate, then you will potentially have a tax liability. And therefore there are various mechanisms to try to mitigate the risk. None of them are perfect, but there are potentially ways around it. For example, transferring shares back to the company and then cancelling them, and all other shareholders therefore going up pro rata. Or if you perhaps have a deferred share mechanism, which is basically a class of shares which are worthless, sometimes you can bake in the ability for those departing founders' shares to convert into worthless shares, which again mitigates against the risk. But it's a very good question and a good point, and something which founders don't always think about or are not always alive to. So yeah, something to be aware of for sure.
Thank you. Another question here. Do you have any ideas or suggestions on contract clauses that would attract and retain new employees into a business with a fair way out if it doesn't work?
Yeah, I can kick that one off. I mean, there's essentially we're talking about, you know, bringing people in from the outside and incentivizing them to stay and participate in the growth of the company, but also making sure that if they leave, the company is not unduly prejudiced. I mean, the answer is there's lots of different ways, and many of them, again, as sort of Tom was touching on for very similar reasons, are tax driven. So, I mean, frankly, if the company has no value and the company shares have no value, the simplest, quickest, easiest way is just to give employees or, you know, sort of co-founders or partners, or however you want to describe them, shares, actual shares, and then you're into the territory of you know, what happens if they leave, and then that's where the kind of good bad leaver type mechanics that we've just been discussing come into play. Now, you may not actually want to give away shares, because, you know, shares are quite valuable, and also obviously carry with them certain rights, voting, dividend, you know, as well as capital. So you may think, well, actually, you know, really the key for an employee is just to be able to participate in the value on an exit, and therefore we're not going to give them shares. We'll give them an option, so a right to acquire shares, and perhaps say that option can only be exercised on an exit. So from the perspective of the employee or the person coming into the business, they know that if they stay with the business, they will be able to exercise their option and essentially acquire a piece of the pie on an exit. And from the company's position, that can be quite nice, because you may put in place certain provisions that essentially say that if they leave for any reason prior to an exit, then their options lapse and cease to become capable of exercising. So you haven't actually given away any shares on day one. You've also got, you know, kind of more complicated mechanics such as growth shares, which entitle employees to participate in the value of a company above a specified hurdle, and they can be particularly attractive, I think, for later stage companies. And then, of course, you know, you've just got the old-fashioned systems of things like, you know, salary and bonus and that sort of thing. But of course, you know, bonus is not particularly tax efficient, because you're into the sort of the income tax regime with bonus, whereas ideally you want to get these people into the capital gains tax regime. Was there anything I missed, Tom?
No, I don't think so. I think on that last point, that's very true. And if you are going to set up an option scheme, you may have heard of what's called an EMI option scheme, which is UK specific and is a brilliant way of incentivizing employees, because what it does is it locks in the market value today, even if you don't exercise your option, become a shareholder. So when you do exercise just before an exit, as long as you're paying the market value on day one, then you don't have any tax liability or no income tax liability, and you just pay capital gains. So it's a great scheme. And with my investor hat on, I would like to see a company have an option pool in place to incentivize employees, and I would like it to be an EMI if it can, because of the tax benefits, and not just to the individuals, but it avoids potential tax charges, national insurance to the company as well on an exit. So it's a great thing to put in place, and not very expensive to put in place either anymore.
And actually, just going on from that one, what size would you want that EMI pot to be of the total cap table?
It really varies. I mean, I would say anything between sort of 15 and 25%, up to 25% is kind of market. So I mean, you know, if the pool is too small, the pool is say 10%, then it's not surprising at sort of Series A or Series B stage for the investor to insist on the pool being increased to an appropriate level. And then, you know, you may get into a bit of an argument, frankly, around how that impacts valuation, and essentially whether the investors take the hit from the increase in that pool, or whether the dilution is felt by everyone pro rata.
Another useful point actually on EMI is, if going back to our first question, if you're a founder and you've been diluted down to a level below where you want to be, and you do agree commercially with your investors that you're going to be topped up in order to incentivize you fully to grow the business, if you're the CEO or whatever, and they want to get you above a certain threshold, then issuing shares at that point later down the line is going to give you a tax charge, but you may be able to still qualify for EMI options, which gets your economic interest up in the company, if not your voting rights, which can be a very useful tool.
Yeah, it's a good point, Tom. And actually it links back to the point we made right at the beginning about one of the biggest mistakes being founders sort of getting diluted too early. I mean, this may almost sound counterintuitive, but what we find is that when it comes to later stage investing, sort of Series A, B, and C, one of the biggest issues from the incoming investors' perspective is that the fact, is sometimes that they feel the founders don't have a big enough stake. So that, that they're trying to achieve a scenario whereby there's a sensible valuation and they essentially get more of the pie, but they very much want to make sure that the founders have a decent slug of equity as well to stay, so that they stay properly incentivized and sort of motivated to grow the business. So it comes right back to the first point about ideally sort of not giving up too much on day one.
What does EMI stand for? I think it's Employee Management Incentive, isn't it? I got that wrong.
I think it's enterprise.
There you go, I'm wrong.
Incentive, yeah, but it's not just for employees actually. I think you can use it if you're a non-executive director and you work a certain number of hours, it can work for you as well. So it's a brilliant scheme, very useful if you qualify.
Okay, I think this question was answered earlier, just to make sure. How do equity buyback clauses in a junior founder agreement work if they should leave, and how common are they? I think, have you covered everything you want to say on clawback, or is there something else to add to that one?
Don't think so for the minute.
Yeah, unless there's anything specific.
No, that was a question before the event. I think it came up during. Yeah. Okay, thanks. How important is it for the board to follow the company's articles, e.g. when looking at shareholder dilution?
Well, I mean, it's a bit of an odd question. It's sort of like saying, how important is it to sort of follow the law, or to follow what you write down in a contract? I guess there's sort of a few different sides of that question. I mean, frankly, legal documents are important and are a sort of backstop and should certainly be followed. But ultimately, lots of them are sort of kept locked away in a drawer, and the practice that the companies may follow may not, may actually be be different in the real world. And we're very sort of sympathetic to the fact that sometimes you need to the commercial imperative overrides what you may have agreed. I mean, obviously, to the extent that directors or the companies don't follow contract or don't follow what they've agreed in their articles, they leave themselves open for risk and liability, and in some cases personal liability. I mean, really, I think the answer here is just to make sure that you have documents that are properly drafted, but also that in certain circumstances leave the door open to some flexibility. So in this specific example about the preemption rights and sort of anti-dilution, I mean, what we always like to recommend is that, particularly for sort of later stage companies, that there's an ability for the board, maybe with a consent of an investor majority or an investor director, to disapply preemption rights, such that if you need to raise money quickly, or you need to the investor has quite a fixed idea of what the cap table looks like, that you can achieve the commercial imperative without sort of being a slave to the process of following the preemption rights. But equally, having the decision to control that being one that involves both sort of board and investor representatives obviously helps sort of balance the interests of the two. So I think the key is not having documents to then not follow them, but just making sure the documents themselves are thought through and include an appropriate level of flexibility, such that you can still follow them but achieve your commercial imperatives within that.
Yeah, I think you've hit the nail on the head there, Tony. And on that note, I guess a point to be aware of and alive to is if you do get a detailed term sheet from an investor, if you can get these types of nuances into the term sheet, that's brilliant, because you'd rather not negotiate for the long form documents, and it can be quite difficult to get movement on things like preemption rights if you didn't have them in the term sheet. So ideally, you would, if you can, at least get a lawyer to have a sense check of the term sheet before you sign it, because a couple of these points can be really valuable in later stage.
I'll give a real life example that's happened to me this morning. I'm one in 10 investors in a company, They've closed a 2 million round in the last couple of months, which is fantastic. They haven't communicated it to any of the investors. They sent the documents. We haven't got preemption, and they've just asked us to sign. And the emails that are going back and forth amongst the shareholders is unbelievable. So it's really important from the investor side of things that you keep them on side, because what could happen as a result of this is that they won't sign and they won't close the deal. So that's the other side of the coin to think of. I've got a question here. I think I'm interpreting correctly. So Nicholas, if I've got it wrong, I apologize. But in an initial shareholder agreement, is there any way that you can incorporate clauses? If I invest, for example, become a shareholder, and I expect to see some liquidity event 3 to 5 years down the line, and that doesn't happen, and the founder sort of takes the business forward as a lifestyle business, is there anything that can be written in the original shareholder agreement that gives the shareholders the right to enforce it, the liquidity event?
Well, I mean, no, it will be very rare for a minority shareholder or an investor to essentially be able to enforce an exit. I mean, I think again, this goes back to sort of opening principles and about why you get into business with someone, and if you and about doing your due diligence from both sides, you know, and a company doing the due diligence on their investor and the investors doing their diligence on the company. So it would feel like it would be a great sort of mistake or error on, you know, of judgment if both parties had a completely different idea about whether the business was going to be more of a sort of lifestyle business or one that's there to make money. You know, having said that, often you do see, you know, some sort of backstop type commercial or contractual clauses, you know, along the lines of sort of using best or reasonable endeavours to procure an exit within a certain period of time, and perhaps a right for the minority shareholder or the investor to appoint a corporate financier if that hasn't happened within a certain period of time, to explore exit opportunities. Equally, you know, I have seen scenarios where if there's not an exit within sort of 3 to 5 years, then the right to control, say, a drag along moves from the majority shareholders to the minority shareholders. But, you know, I stress that the key is making sure that the initial discussions are on point, and that you both have clear objectives for the company, and that one, you know, the investor's not going into this thinking that this is going to be a sort of 10x return in 5 years, if in fact the founder just wants a nice cozy lifestyle business.
Yeah, and I think the drag is important. So for if any of you don't know, the drag provision is typically found in the company's articles, and it can take many different forms, but typically it allows the majority shareholders or a certain threshold to drag the minority shareholders into a sale on the same terms and at the same price, which is a good right for a majority shareholder to have. But, you know, if you're a minority shareholder and you're worried about an exit perhaps not being at the level you're expecting, or you want some control over that process, then you can include a provision whereby, you know, you can't be dragged unless the return is, you know, 5 times or whatever, or 4 times. That's a negotiation. But if you are thinking ahead to an exit, and along with the provision Tony mentioned, then some control over the drag is useful. Or not control, it's a veto over the drag.
What is your view on using safes and ASAs versus convertible loan notes for angel or seed rounds in the UK? And maybe you'd like to just explain the acronyms of SAFE and ASA for the audience too.
Do you want to kick that one off?
Yeah, sure. So starting with a convertible loan note, so I guess that's pretty self-explanatory in that it's a loan that's made to the company, which will typically convert into equity at a discount to the next funding round price, if that occurs. And if it doesn't occur, there might be a long stop date when it will either convert at an agreed long stop price, or it can be repaid in cash, and it will also typically accrue interest. So this is the type of thing that we usually see from, you know, VC investors who might be putting in some bridging finance into a company. And the ASAs and the SAFEs are similar in many ways. An ASA is an advanced subscription agreement, and it was actually kind of born out of SAFEs, which are simple agreements for future equity, and they came out of an accelerator in the US. And they're quite similar to convertible loan notes in many ways, because they're short documents. There is some money invested and there are no shares issued immediately. You don't have to have a fight about valuation. Legal costs are low putting these in place. I mean, they're not standard form, but there isn't a massive amount of negotiation involved typically. The difference with SAFEs and ASAs is that they are not repaid in cash at the end, typically. So what that can mean, particularly in the UK, which is great, is that ASAs can qualify for EIS, which is attractive over a convertible loan note if you're an investor. So they're essentially an investor saying, look, here's £50,000 in advance, and that will convert into equity on your next funding round at a discount. If we get to 12 months, or I think 6 months now is the recommended long stop date for ASAs, then it won't be repaid, but it will convert into equity at an agreed price. So that's the main distinction between ASAs, SAFEs and convertible loan notes. I mean, I think taking a step back and looking at these as instruments, I think they're great in many ways for a company, because you're taking money, you're not actually issuing shares, you're not typically giving any rights away, you're kicking the can down the road in terms of having to negotiate a complicated shareholder agreement, you're not having to have a fight about valuation, which is great. But if I was an investor, I would be a little bit wary about entering into these, because, you know, for the reasons I've just noted, you know, you're not getting any rights, you're not a shareholder, who knows what the valuation is going to be on the next round. It's not ideal. So even though you do qualify for EIS potentially, again, I would make sure you have a conversation with a lawyer or give some serious thought before going down the ASA route as an investor. Yeah,
I mean, as from an investor's perspective, in an ideal world, if tax is not your driver, because you either put the commercial imperative before it, or perhaps you're overseas and therefore you can't benefit from say EIS relief, a convertible loan note is probably preferable, because you have more flexibility and it is actually a loan. So ultimately you can get interest on it, and ultimately if you call for it, it may, you know, it's capable of being repaid. Whereas obviously with an ASA or a SAFE, these are not loan by their nature. They're not loan type instruments. So I mean, they are, you know, you're getting equity, you're just not getting equity on day one. So, you know, but again, I echo all the points that Tom made, but, you know, commercially, a convertible loan note from an investor's perspective will probably put you in the best position, but they're not EIS qualifying.
I don't need an investor myself. I hate them. I'll do equity because, you know, all the risk is with me. Why should I let you just see if you manage to reach what you say you're going to reach? You know, actually, you need to give me the equity today. That's my view. Anyway, what would your advice be for startups or seasoned businesses looking to raise funds?
Well, I mean, I would say this, wouldn't I? But I mean, I think talking to a lawyer at the earliest stage is important. And I'm not just saying that for sort of selfish reasons. I'm saying that because I've just seen it so many times in practice where companies either don't engage, don't get proper advice, and therefore are stuck with terms that are disadvantageous to them. Or actually they get advice too late. So, you know, maybe they've already agreed a detailed term sheet, and then there's they're then faced with a sort of 100 pages of documentation, and they sort of freak out at that point, but it's often too late. So I think getting some proper advice on day one is important. In terms of sort of looking at raising funds, I think it's obviously being investor ready, sort of investor readiness. So it's kind of making sure that all of your housekeeping is in order. Your contracts are signed, you've got employment contracts in place, your brand is protected, you've got trademarks, you've got maybe a data room sort of up and running, so that when investors ask to see your documents, you're not kind of scrabbling around, or you're not looking like you're not organized. And then probably some of the other stuff that we've talked about, you know, being clear on who you're going to be raising money from, being realistic about the valuation you raise at, and, you know, lots of the other sort of points that we've already mentioned. I'm sure Tom's got a few others.
Yeah, no, I think that's right. Particularly when you're approaching venture capital investment, there are certain core due diligence items along the lines of what Tony mentioned, which are absolutely crucial. And I think IP is often a very big one these days. So, you know, if you are engaging developers now, for example, who aren't employees, and therefore the intellectual property that they're developing for you doesn't automatically vest in the company, you need to make sure that you've got them signed up to robust contractor agreements whereby the IP is properly assigned to the company, because this is exactly the type of thing that investors are going to look for, and means you're not having to then go and track down that developer, you know, a few days or weeks before you're trying to get VC investment to try and get them an IP assignment. So I think those kind of items are always hot on the agenda for VCs. And also, genuinely, I don't want this to sound like a sales pitch, but again, if I'm a VC investor, ideally the company that I'm looking to invest in is properly advised and has lawyers that know the market, so that they know when they put sensible venture capital terms in front of them, it's not going to be a ridiculous fight with a lawyer that really isn't kind of an expertise in this area and doesn't understand the VC market, which is quite niche, to be fair. So yeah, I would say echo all the things Tony stated, and then yeah, those areas as well. And of course, you know, on the more commercial side, making sure you've got a good business plan and a teaser, and you're set up, and you're ready to, you know, engage with any investors on the commercial front in that sense.
Do you have a view at all on the benefits and risks of incorporating in a tax haven such as the Cayman Islands or Delaware, from both the investor and founder perspective? Do you have a view at all?
Well, again, if we're talking, it depends where your so much of this depends where your investors are. So if we're talking about UK business angels, then essentially, you know, we're not. You can't be funky with structures. You're talking about, broadly speaking, an investment into a UK company. So, you know, for most investors, particularly if they're UK, I mean, EIS is the best tax relief anywhere in the world. So that will limit where you incorporate. If, you know, if you're not subject to those sorts of risks, and perhaps the business is based overseas, or the investors are based overseas, then of course it calls into question, you know, potentially other types of structural jurisdictions, you know, depending on tax and the you know, the appeal of those sorts of jurisdictions for investors. So it's, I mean, it's not a simple question to answer.
Yeah, and I think this links into an important theme which Tony, you and I often talk about, which is, if you're an early stage business, just try and keep things simple.
Yeah.
Unless there's a compelling reason to go and set up another company in a different jurisdiction, just keep things simple in the UK. Don't overcomplicate your structure. Try and keep it to one share class, unless you perhaps need to have 2 share classes for a venture capital firm. And yeah, in terms of this funky stuff, again, it's often overkill. The UK is a great place to do business. It's transparent on the whole, and the tax regime is fantastic, as we've alluded to. So I think that's a pervading theme of all of this. Where you can, try and keep things simple and don't overcomplicate.
I just want to pop back to the EMI that we spoke about, the stock options. Does it cover service providers at all?
So yeah, it's a tricky one. It doesn't apply to consultants. So there's kind of 3 categories in mind: there's employees, there's directors, and there's consultants. But then you could potentially have a kind of non-executive director that might qualify, although it's unlikely, because they won't have work that, I think it's 25 hours a week you need to work for the company, typically. I should caveat this. Tony and I aren't tax lawyers, but we do know a fair amount about EMI. So typically, no, service providers won't qualify, but occasionally there are some loopholes where you can squeeze them in legally. So yeah.
Is there anything else that a service provider could do instead that you know about to get shares?
Well, they can still get shares.
Yeah.
They'll have what's called unapproved options.
Yeah, exactly.
Which means it's not necessarily a problem for the company because they're not an employee. So the service provider will get options, and then they'll exercise those options in accordance with the terms of the option agreement. And when they do, they'll have to declare the shares they receive in their income tax return, and they'll have to declare a market value for those shares in their income tax return, and they'll have to pay income tax if they didn't pay market value for those shares. So it's not really a problem for the company. It's slightly different if they were an employee, then the company might have to pick up national insurance on unapproved options. So you can 100% still give these types of options to contractors and consultants, and you can in fact use the same EMI overarching scheme to grant the options, which is great. It keeps it all under one place and it's easy to administer. They just won't get the tax benefits which we touched on for employees.
Okay, thank you. In terms of liability caps for founders, what would be a reasonable liability cap for founders in an investment agreement? For instance, 50% of what the investor invested, 100%, 150%?
Well, I assume what we're talking about here is liability caps for breach of warranties. So, I mean, not, you know, clearly, a founder is not going to be liable per se, or personally liable per se, if the investment doesn't go according to plan. But typically, in an investment agreement or in an investment sort of scenario, the founders, along with the company, would give warranties, you know, sort of statements of fact to the investors about the state of affairs of the business that the investors would rely on. And if that's what we're talking about, then, you know, typically from an investor's perspective, you would want the company to be on the hook for 100% of the investment, and the founders personally to be on the hook at a sensible level that would give them sufficient pain to make sure that they take the warranty and associated disclosure exercise seriously. So often that's kind of, you know, an amount equal to sort of 1 times or 2 times annual salary. I mean, you've got the pragmatic issues around the fact that, you know, if there is a breach of warranty, then you know, in practice, unlike a sort of M&A type scenario where you're kind of dealing at arm's length, in a scenario where you're kind of in bed with each other, then an investor is not necessarily going to be wanting to sue the company that it's invested in, because that will devalue its own shares, and is not really going to be wanting to sue the founders who they're relying on to actually motivate and be motivated and sort of drive the business forward. So I find that kind of warranties and sort of risk allocation in the context of an investment deal are sort of more about information gathering and flushing things out that maybe haven't arisen through the due diligence process, rather than where you have an M&A transaction where it's kind of you hand over the company. It's you often have nothing to do with the company going forwards, and if you've sold the acquirer a pup, or you've kind of lied to them, then the acquirer is going to be much more minded to actually sue you for a breach of warranty.
Yeah, I mean, I would agree wholeheartedly. Again, I think with the investor cap on, one thing you can think about doing in terms of warranties, because you don't want to be suing the company for cash, and you don't want to be suing the founders personally, but if there is some kind of black hole in the company that they've not told you about, and there is a blatant breach of warranty claim, then if you've been clever and you've been cute in the investment agreement, you might have the ability to rebase the value of your investment. So rather than suing people for cash, you could be issued with some shares for free as an investor to top you up, to basically put you in the position you had been if the warranty, if it hadn't been the breach of warranty and the company had been the actual lower valuation, if that makes sense. So that's something, it's not very common, but something that I often advise investors to think about. I mean, it's good for VC funds more than angel investors, because I think something like that can potentially invalidate your EIS if you're getting topped up for free. But it's a clever little trick for VC funds.
If you have a crowdfunding round that gives you 50 small shareholders, how can you avoid the need to obtain every single signature for future decisions?
I think that goes back to what we were saying before about whether the crowdfunding round is structured through a sort of direct investment model, whereby each of them actually becomes the shareholder and has the sort of direct contractual rights, or whether they essentially operate through a nominee structure, so that really from a company's perspective, you only ever have to actually deal with a nominee, and there's just one one entity on your cap table and one entity that has the any rights that are agreed. So I think that's probably where the distinction lies.
Okay. Although saying that, if you do have 50 crowdfunders on your cap table, then you could still look to put in place some kind of investor director who has certain decision-making powers on behalf of those 50 people. So if, for example, you needed to get consent for a new issue of shares, it would just be that one crowdfunding investor director whose consent you needed, as opposed to having to go out to all of them, which is great and cleaner, but doesn't get you around the problem of still having that many shareholders. So, for example, if you want to amend your shareholders agreement in future, you'd need to track down most of them in any event. So we typically advise to try and avoid those direct investment models if you can.
I think it's a big question, but at a high level, what are the different terms that go into an articles of association versus a shareholder agreement at a high level?
Well, the key distinction really between the two is that your articles are public document, publicly downloadable and available at a company's house, and the shareholders agreement is a private contract between the parties involved. So, at its core, you'd say that certain information which is kind of more private or sensitive would go in the shareholders agreement. And other information would go in the articles. But I suppose over time there's just developed convention whereby certain things go in the articles, and they tend to be a lot of the more sort of mechanical issues around share issues and share transfers and leaver provisions and that sort of thing. Whereas perhaps some of the more sensitive issues like veto rights or information rights, and certainly things like warranties and sort of disclosures, would go in the shareholders agreement. I mean, there's also the separate issue of in order to be any shareholder, whether or not they sign anything, is automatically bound by the articles, whereas they positively would have to sign a deed of adherence to be bound by the shareholders agreement. So again, it kind of depends on what it is that you're trying to do to future-proof the company and the extent to which you want to make sure that future investors are bound into your governance structure, whether or not they actually sign anything. Is there anything to add on that, Tom?
No, I think that's spot on. I think there's a boring tax point about actual rights attaching to shares needing to be in the articles as opposed to in the shareholders agreement. But yeah, not really interesting, that one. So yeah, I think you nailed it.
We covered off contractors earlier and EMI. Would that, exactly what you said, still apply to foreign contractors that aren't based in the UK? Yeah,
so it's the same analysis.
Okay, fine, thank you. For a team just starting out, what would be some good sources for getting legal aspects in order, such as the shareholder agreement, etc.? I'm going to laugh at this. Is it worth investing in legal advice in the early stages?
Yeah, I mean, I really think it is, just because there's almost a frightening amount of things that can go wrong. So I strongly think it is sort of investing in some legal advice early on. But actually, I think the key is that trying to work with a lawyer that understands your business and understands that maybe you have a limited budget in mind, and therefore, typically it may be that there's 100 things that ideally you would put into place, and you would have the most perfectly written policies and contracts of for everything, but actually there's not an unlimited budget. So it's kind of back in the real world. What's the budget? What are the immediate priorities? And actually, it may well be that there's lots of things that can be separated out into the sort of the must-haves and the nice-to-haves. And I think that's where getting good kind of commercial, solid legal advice, and people who are sort of in it for the long run, not just sort of short term, can help. Because I think a lot of it is about trying to analyze what the priorities are and what are the things you have to do on day one, or or frankly that you should have done yesterday, versus what are the nice things to have, or the things that we may tackle you know, post investment or post Series A when there's a bit more money to play with?
A very general question, which I think is just a yes or a no. Can foreign founders incorporate companies in the UK?
Yeah.
And I don't know if you know about the right to work. Probably a bit more complex, I think, that question.
What do you mean?
If they incorporate a company in the UK, that doesn't automatically give them the right to work in the UK, does it?
No.
No.
So we're not. Yeah, I don't think we should stray into immigration law in this.
No. Do you know any blogs, books, or articles that are useful from a legal perspective? I doubt that that's what you're looking at as lawyers. You've got better things to do in your spare time, probably.
Well, Tom likes to read a lot of those blogs and stuff, don't you?
Yeah, I'm a bit sadder than Tony, sadly. I don't know. There's a few good books on venture capital investments which you can just find on Amazon. I can't remember the names. I read a couple when I was starting out, because it's a bit of a niche world. It's a bit unusual. Even if you know a bit about corporate law, the venture capital world is different, and there are these quite bespoke terms which venture capital funds look for. So I can try and dig out one of those and give it to Charlotte for a recommendation, perhaps, and she can pass it on to the group later today. I can't remember it off the top of my head.
Okay, I guess very open-ended question. Probably what everybody wants to know: how much does early-stage legal advice cost?
That really is like, how long's a piece of string? I mean, again, I think it goes back to the point I just made, which is that it depends what it is that you're trying to do. So, I mean, if you're putting in place, policies and contracts for every single eventuality, and you're trying to, you're essentially treating a startup as if it was, sort of Microsoft, then clearly fees are going to be astronomical. So it's about identifying what the key must-haves are, and then putting in place a sensible budget for what those are. As to how much it all costs, I mean, it's such an open-ended question. Can't really answer it meaningfully. But I think it's not really about how much things cost. It's about the value that you're getting, and perhaps about being a bit creative with the help of a creative lawyer about when the fees are actually paid. So, we certainly recognize that, very early stage companies don't necessarily have much money. They're bootstrapping, and until they get investment in play, they simply just don't have money to spend on lawyers. That's not to say that they can't engage lawyers and come to some sort of arrangement such that, the fees are payable from the investment proceeds. So I think it's just about being creative and not being afraid to sort of have some conversations with lawyers. I mean, certainly, many of us now don't operate solely off the basis of kind of the old-fashioned sort of stick a meter on and just charge by the hour. So there's all sorts of flexible ways of operating, fixed fees, capped fees, contingent fees, all of this sort of stuff. And certainly at my firm, we're very alive to all of this, and we're very happy to accommodate any types of different structure.
I think I'll also just give a first-hand example that Tom brought up earlier about investor-directed consent, for instance, on the paperwork that I've worked with Harbottle's previously. We gave that to our investor director, and it's prevented us having to go back all the time to create written resolutions to get passed, because we've got investor-directed consent. So it's saved us quite a lot of cash by doing that kind of creative thought process. Two last very quick questions, if we can make them quick, because we're literally at 7 o'clock. What are the considerations being asked for a 1 times or 1.5 times liquidation preference? Are they common in the UK? And I guess you probably just have to very quickly explain the liquidation preference to the group, please.
Tom, do you want to take that one?
Yeah, sure. So we touched on it briefly earlier, but typically a liquidation preference is required by a venture capital investor from Series A onwards. And what it means is that if there is a liquidation of the company, so if things haven't gone well and you're winding the company up, after all of the creditors are paid back, if there's anything left, then the shareholder with the liquidation preference will get their money back first. before any of the ordinary shareholders or the founder. So that's kind of the most basic type of liquidation preference. It's a one times because you get your money back. But there are different alternatives. So there are like participating and non-participating. So non-participating is the version I just talked about, where you just get your money back. Participating is where you get your money back and then you also convert into ordinary shares and get to benefit from anything above what you would have got back if you just got your money back. So these don't just apply on a winding up, they also apply on a sale. So again, it's often a question for the VC fund whether they want to actually stay as they are as preferred shareholders and get their money back, or convert into ordinary shares. That would be the decision on a non-participating preference share. But if they had participating preference share, they wouldn't need to worry about that because they get their money back and then they participate anyway. So that's a slightly more aggressive version of the liquidation preference.
And they're common in the UK, Tom? Not
very common in the UK, no. I mean, we were worried we were going to see more of them as a result of Corona, but we haven't, thankfully, so far. And also, in addition to perhaps going from a non-participating to a participating preference share or liquidation preference, you also sometimes used to have, or Tony tells me, you used to have like 2 times liquidation preferences or 1.5 times, which means, again, you get 2 times your money back before anyone else in the shareholder base participates. But again, not something we see here very often.
The market practice in the UK for a venture capital fund at Series A stage will be to take a 1 times non-participating preference. And as Tom says, there was a fear that the pandemic could have resulted in sort of VCs taking more more aggressive term participating preferences or 2 times preferences, but thankfully that doesn't seem to be flowing through. I think not least because some of the some companies that are hot are going to get the money regardless, and they're going to engineer sort of competitive sort of tension, and also because I think VCs nowadays are increasingly worried about reputational risk and not wanting to be seen to be being exploitive. So.
And last question to close up, is there a best practice template that can square away 90% of the issues?
No. I mean, if anything, I would say it's the opposite. So again, the biggest mistake one of the biggest mistakes that a founder can make is taking on money from an investor and thinking, right, I need a shareholders agreement. Can I get a shareholders agreement? Can I get a template shareholders agreement off the shelf? Because in my mind, I need a shareholders agreement, or it's almost a requirement to have a shareholders agreement if I'm taking on investment. Whereas number one, it's not a legal requirement, and number two, the only purpose a shareholders agreement serves really is to protect the minority shareholders and to give rights to the investors. So if you start from that preface of 90% of the stuff being in a shareholders agreement being for the benefit of your minority shareholders or your investors, you can very quickly see that there's no such thing as a template or a one-size-fits-all solution, because you're dealing in the grey rather than the black and white.
Okay, we will just allow this one to end it completely. What do you think about the services such as INSEAD Legals? Okay, this is the final question, audience.
Tom, I might say something undiplomatic.
Yeah. So, I mean, we've been on the other side to INSEAD Legals a couple of times, or we've actually acted alongside INSEAD Legals. So INSEAD Legals acts as the platform preparing the docs. We've actually been advising clients on the actual terms, and obviously I'm biased, but no, I think it's okay if it's incredibly early stage and there's no negotiation whatsoever, and you're literally just want a robot to put some terms that you've selected from a spreadsheet into a document. I think it's okay for that. But if there's anything above that, then it's incredibly cumbersome, and each time there's a change that's so slightly bespoke, then they've got to write new code, and it just dragged on, and it was a nightmare for anything above the most basic stuff. But obviously, respect what they're doing, and in many ways they are driving down prices for consumers for the early stage work, and that's a good thing, I guess, for consumers at least. So yeah, I get it, but I wouldn't recommend it. I think I think because the way they have affected the market, you can actually get a proper lawyer at an early stage now for not that much more from a cost perspective. So there are lots of good things to be said for that, but yeah, I wouldn't recommend them. I really wouldn't.
I mean, well, it's a different, comparing us to Seed Legals is apples and pears. I mean, we're a premium, you know, we're a premium legal services provider, one of the leading venture capital firms in the country, and it's a totally different proposition. So that's not to say that Seed Legals don't have a place in the market, or that, you know, again, to use sort of some of the analogies before, can sort of get you from A to B, you know, in certain circumstances, but they won't get you from A to B to Z.
Okay, and on that one, we'll close off. So a virtual round of applause for Tom and Tony for giving up their time. Thank you very much. And also for Katie and Liz helping pull this together. I hope you all found that useful, and Katie will, I'm sure, send a follow-up email with information. Thank you, everybody. Good evening. Thank you.
Bye. Thanks, everybody.